Hello, everybody. It is wonderful to reconvene as a plenary for International Law Weekend. I know many of you are still joining. I've seen a few of you already popping in and out of Zoom rooms and attending plenaries and panels throughout the weekend. For those of you joining for the first time, welcome. This is the 99th annual members meeting for the International Law Association American branch. And this is, I don't know which International Law Weekend we're on. They started in the 1970s, but we've been doing this for many, many, many years. Over these 3 days, we'll have approximately 32 panels. 19 offer CLE, and CLE credit is free. Thanks to White & Case, one of our sponsors. We have almost 200 speakers, 1,500 registrations, and the attendees and speakers come from at least 70 countries. And our ILW administrator tells me that the number is increasing every day. I'd like to thank our 25 sponsors, including especially our diamond level sponsors, Arbitration Place, White & Case, and Debevoise. And I'd like to thank enormously the team at Arbitration Place, particularly Heather Damour, Kira Balach, and Jeffrey Hill, our ILW co-chairs, Nawi, Julian, and Amity, who are working furiously behind the scenes, the entire ILW organizing committee, and you can see a picture of them on our website if you go there. Ruxar Azame, our media officer, Maddie George, our ILW administrator and membership officer, our 8 student ambassadors that come from a variety of different law schools, and all of our committee chairs, as well as my co-leaders, Michael Scharf, who is our president-elect and will take over next year, and David Stewart, our current chairman. Today, you will find, following this particular event, many panels on several interesting subjects, including the crime of ecocide that I'm happy to speak on, but many, many other discussions as well. And then this evening, we have our committees holding networking rooms, and do encourage you to join. And if you're not already a member of ABILA, please do consider joining. This is our centennial. We're going to have a lot of exciting events for the centennial year. And next year, we plan to be meeting in person at Fordham Law School to celebrate 100 years of international law. As some of you know, we're one of 63 branches. We are headquartered in London. The ILA headquarters is in London, and the American branch, probably should be called the US branch, is one of 63. And one of the most important activities that we undertake is study and formulation of rules of international law through these international committees. Tomorrow will be our 99th members meeting. Fatou Bensouda will give the opening address and receive the Outstanding Achievement Award for our organization. And we will conclude International Law Weekend with a special career session. Thanks to Amity Boy for organizing that, and the International Law Students Association for co-sponsoring and putting that together. If you're looking for help, we have a help desk for all ILW attendees, and CLE credit, as I said, is available. And with those housekeeping rules, let me just say one other thing. We have enabled the chat so that during Professor Hathaway's talk or later on in the weekend, you can chat to each other. Obviously, please keep it courteous and on point. And in addition, you can pose questions to Professor Hathaway or really in any of the panels through the Q&A function. I'm thrilled now to move to our main event. And even though Nawi Ukabiala is going to formally introduce our speaker, I just have to say a couple of words about Professor Hathaway, who I think is truly one of the leading lights of the Academy in thinking deeply about international law, combining a profound respect for the sort of constitutional structure and normative value of international law with empirical methodologies, archival research, and really engaging in scholarship that changes the way people think about our discipline. And that is, I don't say that lightly, but I think she really is one of the leading lights. And her book, The Internationalist, co-written with Scott Shapiro, is recommended, required reading for every student who wants to understand international law, how it's made, and what its purpose is. So now I'd like to invite Mr. Nawi Ukabiala, one of our co-chairs for our organizing committee to formally introduce Professor Hathaway, and then the two of us will be moderating after she concludes her remarks. So thank you very much for being here, everybody. And Nawi, you now have the floor.
Thank you, Leila. It's a pleasure to be here. And Leila, you are in ILW 2021. Just wanted to take the opportunity to thank you for tremendous leadership and of ABILA over the years. I'll now introduce Professor Hathaway. She's a professor of international law at Yale Law School, professor of international law and area studies at the Yale Macmillan Center, professor of the Department of Political Science, and director of the Yale Law School Center for Legal Challenges. Counselor to the dean at the law school, member of the advisory committee on law for the legal Department of State since 2005. From 2014 to 15, she served as of the U.S. Department of Defense, where she was awarded the Secretary of Defense Award for Excellence. She's also a highly accomplished publicist, having penned over 30 law review articles and co-authored the book, The List, How a Radical Plan to Outlaw War Remade the World. We couldn't be more delighted and privileged to have her deliver the law, a threat to the international order. So without further ado,
Nawi, can you lean forward? We can't hear you very well. Sorry.
Oh, sorry. Can you hear me now? Great. Okay. So without further ado, I'll turn it over to Professor Hathaway to deliver her keynote address, War Beyond Law, a Threat to the International Order.
Thank you so much for that kind introduction from both of you, Leila and Nawi. I'm really grateful to you both, and grateful to be here with all of you on this Friday. So I'm going to provide a few slides to give a little structure to the talk, and I'm really eager to hear questions and thoughts from the audience. I consider this a collaboration among people with shared interests. So thank you again so much for having me here. So as Nawi rightly said, the subject of my talk today is War Beyond Law, a Threat to the International Legal Order. And I want to cover three basic topics today. First, I want to kind of lay just a basic groundwork for the prohibition on war and the modern legal order, just laying out the kind of basic foundation of the international legal system that we are lucky enough to enjoy. Then I want to talk about some of the key challenges to that system, in particular cyber operations, partnered operations, and self-defense, particularly the expansive use of self-defense over the last several decades. And then I want to conclude by looking ahead and inviting some conversation with the group here about things that we can do to try and address and meet these really important challenges to not only the prohibition on war, but to the foundational principles of the international legal order. So, so first I want to take on the prohibition on war and the modern legal order. So as Leila mentioned, I wrote a book with my co-author, Scott Shapiro, The Internationalists, How a Radical Plan to Outlaw War Remade the World. And the central argument of that book was that in what we call the Old World Order, war was perfectly legal and legitimate, might made right. The foundation of the international legal order was that states could use war to resolve their disputes between one another. And that there was a key change that took place in 1928, first with the Kellogg-Briand Pact, and then over the course of the interwar period, the reinstantiation of those rules and reaffirmation of them in the United Nations Charter. And this was, we argue, a key break from the past. This idea that states could no longer go to war with one another was essential to what we have come to know as the modern legal order. The 1928 Kellogg-Briand Pact, as I said, gets reinforced in the lead-in to World War II. The Atlantic Charter declared that nations of the world must come to the abandonment of the use of force. This was a principle that was initially stated in the Kelly-Briand Pact and was reaffirmed in the Atlantic Charter, which then becomes the foundation of the declaration by the United Nations, the first use of the term United Nations in this fundamental declaration, where a number of states join this commitment along with the US and the UK. And then it becomes a central principle of the United Nations Charter in 1945. And we see it in Article 2.4, which states all members shall refrain in their international relations from the threat or use of force. And there's very limited exceptions to this requirement. Security Council authorization under Chapter 7, self-defense under Article 51, or consent of the host state. But whereas war used to be perfectly legitimate for a whole range of different purposes, for debt collection, for resolving disputes, for interference with trade relations, for a whole range of possible causes, the modern legal order limits substantially the purposes for which states can use war, limits the instances in which they can unilaterally resort to war. And that has been foundational to our modern legal order. I lay this out in more depth in the book, and I don't want to go into it in too much depth here. But the central claim is that the prohibition on force is not just one rule among many, but it is the foundational principle of our international legal order, that once force became prohibited, when states could no longer unilaterally resort to force, that forced a shift in what had been a long accepted principle that states could conquer territory from one another and keep it, that was legal and legitimate. Once war was no longer legal, conquest also was no longer legal. In a world where war was legal, there was no such thing as a crime of aggression. Aggression couldn't be criminalized. And in fact, after World War I, there was an attempt to try Kaiser Wilhelm II, and the Dutch wouldn't turn him over because the argument that they made, which was right, was that there was nothing illegal about waging an aggressive war. After World War II, by contrast, when there was a decision to try the Nazis, it was permissible to try them for the crime of aggression because in the interim, Germany had signed the Kelly-Briand Pact, the Prohibition on War, which did make war illegal and thus provided the foundational principle that was necessary for the prosecution at Nuremberg. And whereas war was perfectly legal and legitimate, and in fact gunboat diplomacy was legal and legitimate, a state could be forced into a treaty at the point of a gun and then be held to the requirements in the treaty under the Old World Order. Once war was no longer legal and legitimate and states couldn't resort to war unilaterally, coerced agreements also became illegal. And you see this in a variety of documents, but most importantly in the Vienna Convention on the Law of Treaties. And Hirsch-Lauterpacht's commentary on that indicates that it was necessitated by the evolution of the Prohibition on War, that once war was no longer permitted, then the threat of war in order to bring about a treaty obligation was also prohibited. And last but not least, in a world where war was legal, states couldn't use economic sanctions against belligerents without inviting war against themselves without violating their obligations of neutrality. And in a world where war was now illegal and illegitimate, states could use economic sanctions against belligerents without violating their duties of neutrality. So the key point for these purposes is just to say prohibition on war is not just a principle, it is a foundational principle of the international legal order. And that means that the challenges that we're facing today are all the more important. They're not just threats to one legal principle, they're threats to the international legal order as a whole. Now, this list that I'm going to talk about today is not exhaustive, but I mean to illustrate what I think are some of the key recent developments that really put at risk this prohibition. And then I'll speak very briefly about what I think might be some ways ahead in terms of addressing these challenges, but I will also invite all of you to jump in and offer your ideas. So first, cyber operations. As I'm sure those who are here know, most cyber attacks to date have not been significant enough to trigger the Article 2.4 prohibition on use of force or Article 51's requirement of an armed attack. Most are what's called below the threshold attacks, meaning they don't meet that threshold for Article 51. But what is distinctive about this era is that there has been a massive expansion of these kinds of below the threshold attacks, and even a few cyber attacks that have edged up to and perhaps even tripped over the line for prohibited use of force under Article 2.4. And what we're seeing is this this exploitation of what has been a fairly gray space in international law by states. States increasingly using cyber operations to do things that they can't do through conventional means. So this is an image of the Natanz facility in Iran, the centrifuges. Famously, there was a cyber attack that's been generally attributed to Israel and the US against the Natanz facility, which caused these centrifuges to basically break at a faster rate than they otherwise would have, and is deemed as a remarkably successful cyber attack at setting back the enrichment efforts of Iran towards developing enough material for a nuclear weapon, but also one of the first serious cyber attacks that is known of from a state or multiple states against another state, and one that still is mentioned as kind of one of the cyber attacks because it caused millions and millions of dollars of damage that may have even edged up to the line prohibited by Article 2.4 because it caused so much damage to property and actually caused a physical destruction of devices at that facility. More recently, and there have been many of these attacks, so I could go on for a long time, but just one of the more recent ones is a SolarWinds attack, which undermined not just private facilities, but government computer systems across the United States, and has been attributed by the United States to Russian foreign intelligence services. It's one of many similar cyber attacks that has been attributed to Russia by the United States. And again, illustrates the kind of increasing use of these cyber techniques by states against one another to undermine their government facilities and capacity to govern. And Joe Biden this summer said that if the United States ended up in a real shooting war with a major power, it could be as a result of a cyber attack on the country. So what begins in the cyber arena doesn't necessarily stay in the cyber arena. If there is a significant cyber attack, say a shutdown of the electrical grid or other significant impact on critical infrastructure, states may be tempted to respond with kinetic force. If in fact a cyber attack did trip over the line to be a Article 51 attack, then a state would not be prohibited from using kinetic force to respond to it. But even these low-level attacks coming at a regular tempo are creating a great deal of difficulty for states, and states are having difficulty figuring out how to respond to them. And this remains a relatively an area where the law is not well worked out. The UN has two ongoing efforts to try and continue to spell out the law in this space. Neither of them has really come to very significant conclusions as of yet. There has been agreement that international law does apply in cyberspace, which is an important development and is an important first step. But exactly how do they apply? What kinds of operations are permitted or prohibited? That remains still uncertain and undeveloped and remains a bit of a gray space in international law. And as long as it remains a gray space, it will be exploited by states, and it is being exploited by states, and creates this real danger of not just ongoing conflict in the cyber arena, but potentially spilling over into kinetic warfare. Now, second area I wanted to say a few words about is partnered operations. There's been a massive increase in the use of partners to carry out operations around the world. One example of this is the U.S. Has partnered for several years with the Syrian Democratic Forces in Syria. These are groups that are Kurdish forces that have been working to try and protect themselves, but also have been fighting against ISIS. The U.S. has provided arms, has provided intelligence, has provided even embedded forces, has provided funding and various kinds of support to the Syrian Democratic Forces. One of the questions that remains to be answered is what kinds of legal responsibility does the United States then have for the actions the Syrian Democratic Forces take? If, for instance, there's abuses of detainees, is the United States responsible for that? If the Syrian Democratic Forces go to war against Assad's regime, which is still the legitimate governing forces of Syria, is that imputed to the United States? Is it responsible for that? And does it, in a sense, then become an Article 2.4 violation potentially? And because Syrian Democratic Forces do hold territory in the northern part of Iraq, and the U.S. is providing significant support to those Syrian Democratic Forces, arguably, they are engaged in a fight against Assad and his forces, and the U.S. providing support for actions that it couldn't directly take raises real questions as to whether this is a big loophole for the prohibition on force, and whether it creates challenges both for jus ad bellum and jus in bello in the modern era. And it's not just support for non-state actor partners, it's support for state partners as well. So one example is the Saudi-led coalition that has been engaged in military operations in Yemen for a long time, partners with a number of states, US included. And these states are providing support to the Saudi coalition as it's engaged in military operations throughout the country. And those military operations have included some strikes that have had major international humanitarian catastrophic effects. Cholera treatment plants have been blown up, buses have been blown up, weddings have been hit. And what responsibility do states who are enabling the Saudi-led coalition have for those international humanitarian law violations? What kinds of limits do partner states need to put on the actions that their partners are taking? And what kinds of limits can they take? What are the legal responsibilities? There's some development of the law in the area of state responsibility. We still have the draft articles. There's still the draft articles on state responsibility, which remain one of our most important texts that we rely on. But that remains still to be filled out. The rules still are not fully adequate. It remains the draft articles, not even a treaty, and not even final articles. And so these rules, I think, once again, the uncertainty about the obligations that apply to states that are partnering with other states and the ways in which their actions then are imputed to the states that are providing that support create this gray space that a lot of states are exploiting, and that then becomes a way of undermining the prohibition on force in really damaging ways. And the last, and one I want to spend the most time on, is self-defense, because it is the area in which I think the greatest challenges have been faced, because we've seen a massive expansion in the scope of activities that fall within what is claimed to be the basis, a self-defense legitimate basis for military operations. So I won't read this all, but you all are probably familiar with Article 51 of the United Nations Charter, which does give states the right to use military force in self-defense. This is an exception to Article 2.4's prohibition on use of force. And it's cabined, though, to instances where states have been subject to an armed attack. Now, there's been a great deal of work over time questioning whether it really is meant to limit to instances where there has been an actual armed attack, if there's an imminent attack. There's general agreement that if an attack really is imminent and there's no other way to prevent it, that an act of self-defense under Article 51 is permissible. But that then has been expanded much further to entail a whole range of activities where defense is beginning to look an awful lot like offense. So let me give a few examples. When Russia invaded part of Ukraine, Crimea, and incorporated it into Russia, to the extent that it attempted to offer a legal justification, and to be truthful, it didn't always make an effort to provide significant legal justification. It initially denied involvement. But when it did accept its involvement, the key justification that it provided was effectively a self-defense argument, that it was acting in defense of Russian military personnel in Crimea. The Black Fleet is long been housed in Crimea, and Russian citizens in Crimea were threatened, was the claim. So it was a defense of nationals claim. So it was, at least to the extent that there was any effort at justification for this operation, that was one of the key justifications that was given, is self-defense on behalf of nationals and on behalf of Russian forces. The United States has championed the so-called unwilling and unable test, but it's really important to point out that only 10 states have explicitly endorsed it. And this I'm drawing from Elena Chachko and Ashley Deeks, who go through and categorize all the states that have explicitly endorsed this principle, who have voiced soft support, who have opposed it. Even if you take every state that has voiced a view, it's still a radical minority of states that have voiced any view whatsoever, one way or the other, on the unwilling and unable test. And the 10 states that have come out in favor include a lot of states that use force, who have used this to justify their use of military force. The states we don't hear so much from are the states that are on the receiving end of that use of force, or the less likely to use force themselves. For instance, one example of a case where the U.S. relied on this justification was in its use of force against ISIS directly, not only through SDF forces, but directly through direct strikes against ISIS in northern Syria. This is the Article 51 letter that was filed by the United States explaining the justification for use of military force in the northern and throughout Syria in 2014, and in August and September 2014, explaining that this was necessary to defend the United States because the regime of Syria was not willing and not able to prevent the threat to the United States posed by ISIS. And we've seen that the U.S. is not alone in taking the position that it can file Article 51 letters against non-state actor groups. We've seen a real increase in the use of Article 51 letters being filed against non-state actors. And almost all of those rely on some version of the unwilling and unable test, because there are instances where you're using military force against a non-state actor group in a state that has not consented to the use of force. If the state had consented to the use of force, then you don't need to file an Article 51 letter. So they're filing an Article 51 letter to explain the use of force against a non-state actor group in a state that's not consenting to that use of force. And the incidence of these claims has gone up radically in the last several years. We even see instances where not only are states using a justification of self-defense against non-state actor groups, but the U.S., in what I think is a fairly troubling development, justified use to self-defense justification in defense of non-state actor partners in northern Syria. So this is combining the partnered operations and self-defense into one new idea, which is we're working through these non-state actor groups, the Syrian Democratic Forces in northern Syria, and they were coming under attack from the Assad government. And the U.S. Justified responding to those attacks as an act of self-defense, even though we weren't defending ourselves precisely, we're defending non-state actor groups that were, for all intents and purposes, acting illegally within the state, not with the consent of the Syrian government, obviously, because it's the Syrian government that was attacking them. So this creates a kind of spiraling of the self-defense justification in ways that even in this instance, we had to deconflict with the Russians. There was a call to the Russians to be clear that there was a deconfliction effort. Whenever we're going directly against the Syrian government, it creates real possibility of coming into direct conflict with Russia, because Russia, of course, is partnering with the Syrian government in the same way that we're partnering with non-state actor groups in northern Syria. And these justifications are not limited to the U.S. I'm focusing on the U.S. I could make a similar set of arguments about a number of states. Here's one where I argued in the Washington Post that Turkey, when it intervened against Kurdish groups in northern Syria, it was doing so on the exact same self-defense justification that U.S. has been using. So the irony of ironies is the U.S. is using self-defense to support and defend the Syrian Democratic Forces, and Turkey is using a justification of self-defense to attack those very same forces. The danger here, of course, is that the possibility of bringing NATO allies into direct conflict with one another, both of them claiming that they're acting in self-defense. And this really creates some very dangerous situation in northern Syria. And I think illustrates that the self-defense justification has really gotten out of control. We saw this as well when the Trump administration killed General Soleimani in Iraq. So he's an Iranian general, but he was located in Iraq. And the U.S. invoked self-defense as a justification for the attack. Even Republican senators walking out of classified briefings said they didn't buy the justification that was being given. There are a number of arguments that have been made that this was not a proper use of self-defense. And this is a quote brought from the Special Rapporteur on Extrajudicial Summary or Arbitrary Executions that shows the concern that the Special Rapporteur had that this escalation, this use of self-defense to use force in a third state against a state, a leading figure of the government, creates a real danger of undermining the prohibition on use of force. And the Biden administration has continued to some degree this view of self-defense, taking strikes in Syria against Iranian-backed militias that had engaged in attacks on American forces, on a base housing American forces, killing one non-American contractor. And the justification after the second response, this image just shows the first in February, but there's a second in June. The Pentagon spokesman said the U.S. acted pursuant to its right to self-defense. But again, most international lawyers who commented on this thought this didn't seem to meet the requirements of self-defense. It wasn't clear there was an imminent attack. It wasn't clear it was in fact necessary, though they claimed that it was necessary. And it's not clear that this actually meets the justification and requirements for self-defense. And it continues to open the door to increased use of self-defense as a justification for use of military force in instances that really may be inappropriate. Okay, so looking ahead, what do we do about all of this? Let's say I'm right. Let's say that the prohibition on force is really this essential principle of the international legal order. It's foundational to the international legal order and to the peace that we have known since World War II. It's not been perfectly peaceful. Obviously, there have been instances of military force being used, but much more peaceful than the eras that came before. And that these challenges really put at risk that prohibition and raise the possibility that we might be headed towards a time of greater conflict between states and even perhaps greater conflict between great powers. What do we do about that? And I think that this moment is really an important moment for critical reflection. So not only have we been seeing this gradual escalation of a variety of areas of challenge to the prohibition on use of force, but the decision of the United States to withdraw from Afghanistan and the rapid collapse of the Afghan government raises real questions about whether the techniques, the tools, the strategies that we have been deploying to fight terrorism are the right ones, and should be a moment for us to step back and ask whether we have been pursuing our aims of keeping our population safe from terrorist activity, if we've been using the right tools. So I think first and foremost, we have to recognize that force is not the only and is rarely the best counterterrorism tool. Yes, there is some place for force in a counterterrorism policy, but it's become too easy to rely too heavily on force as the tool. A lot of social scientific research makes it clear, for instance, that one of the key predictors of whether a city is going to fall to terrorist attack and to terrorist group is whether there is legitimacy of the government in that city, whether there's rule of law, whether there's a sense that justice is being fairly provided to all members of the population, whether the government is able to provide very basic services that are needed by the population. And where that is not present, these towns are much more likely to fall to terrorist groups that that come and invade, and that there's much less difficulty for those terrorist groups taking over. So we need to be thinking about whether, in fact, the best thing we can do is fight these groups once they take hold, or whether we should be investing more fully in foreign aid, in justice reform, and rule of law reform, and a variety of kinds of reforms in these areas, as opposed to simply relying on use of force. And maybe we should take some of the money that we've been spending on defense and the Pentagon and move it over, as even some generals have endorsed, and put it into foreign aid to provide greater support for schooling and basic social services in these places. Second, I think, since I'm speaking to a group of international lawyers, scholars, and practitioners, I think one of the important things that we can do is to fill in these gray spaces, because one of the reasons that states are exploiting these areas is because these remain relatively underdeveloped bodies of law. We can clarify those legal rules, and we can push back on unsubstantiated and unsupported legal claims. I think the general public's not really in a position to know what international law allows and doesn't allow, and it needs interpreters. And that's a role that we all can play, and I think we all should play and take some responsibility for when the state takes an action to calling out actions that we think are not permissible, that we think are in tension with the UN Charter, that we think might be illegal. That's an important role that we, as experts in international law, can play. And I think last, we really need to broaden the scope of voices and views on the developing law and the use of force. We tend to rely too heavily on those states that are well-resourced, that are in a position to be able to put their views about use of force out there. And those happen to be, in many cases, the very same states that are using military force. And so we're seeing just a narrow slice of views of states who happen to have a very particular set of views about use of force. And we, as I mentioned, with the unable and unwilling, there are only 10 states that have taken sort of explicit views endorsing the unable and unwilling test. And the vast majority of states either haven't expressed a view or have expressed a view of either very tepid support in the case of a very small number of states, or opposition. But the vast majority of states have been silent. And they've been silent because they don't have an easy way to articulate their views. And we need to do a better job of getting a range of views on use of force, particularly at a time when law is very much in flux, and where there are areas of law that haven't been yet fully filled out. We need a broader range of voices on these issues. So with that, I am eager for your questions and look forward to hearing from all of you.
Thank you so much, Professor Hathaway. That was just magisterial, and you never disappoint. And it's a combination of the understanding of the deep structure of international law with data, right? With actually looking at the world, and we're just so grateful. As you can see, there are many, many questions in the chat. So perhaps I'll throw out the first one, and in addition, add a little bit of nuance to it if you can. And I noticed that this came up yesterday, and in fact, Pablo Arocha, who spoke to this issue in the opening plenary, has pointed out in the chat that Mexico has put out a proposal on exactly the self-defense issue. So actually, I think we have until 12, Angela. This is a longer session. So anyway, so the question that comes up then is, with this unable or unwilling, what I have seen some scholars even argue is that the Security Council, by approving of it, at least implicitly, has somehow now bootstrapped this 10-state theory into binding international law. And can you speak to that? Because of course, the same states violating international law are often on the council, thereby using the council's authority to kind of bootstrap that. But I think that goes maybe to Professor Trahan's question, as well as I'm kind of adding my own nuance. Thank you.
Great, thank you so much for that, Leila. That's really thoughtful and a really important question. I think that we have to be really careful to not to read too much into the inaction or action of the Security Council. First of all, as you mentioned, many of the states that are on the Security Council are the very same states that are using military force. And there's a great debate about this question of whether specially affected states should have a particular view. Kevin Heller's written a fantastic article on this point. And he makes the point, and this is my view, that merely the fact that states are using force doesn't make their voice more valuable or relevant than the voices of those who are not using force or who are subject to the use of force. That all states, in a sense, are specially affected because of the centrality and importance of the international prohibition on use of force. And all states stand to lose if this prohibition goes by the wayside. And the Security Council was specifically set up as it was precisely to avoid states from engaging in recourse to unilateral use of force. The UN Charter, the foundational principles of it prohibit the unilateral use of force. And the idea that states wouldn't be able to use, that there was a veto given to every member of the Security Council was precisely because they didn't want to have a state be able to use military force and potentially come into conflict with another great power. So this is a central underlying principle of the UN. And I think the idea that somehow the Security Council can bootstrap this into this principle that's only been endorsed by a small number of states into binding international law without following any of the other sort of ordinary rules of international law, I think it's a misperception, and I think we should all resist that idea.
Thank you. Nawi, do you want to pose the next question? And I see you've got your headphones, so we can hear you properly now.
Yes, can you hear me well?
Yes.
Great, thanks, Leila. And since you couldn't hear me so well earlier, I'll just say a couple of words about Professor Hathaway. She's a professor of international law at Yale Law School, and holds multiple leadership positions at the Yale University. She served on the advisory committee on international law for the legal advisor at the United States Department. And from 2014 to 15, she served as special counsel to the General Counsel of the US Department of Defense. She is an extremely accomplished publicist, and we couldn't be more delighted to have her. Your keynote was incredibly eloquent and very timely. My question is, as we know, the application of the warfare paradigm to counterterrorism has really presented challenges to international law in the past 20 years. In your view, does the potential application of a cyber warfare paradigm to counterterrorism pose unique challenges to international law, especially at a time when we're seeing kind of the global governance of counterterrorism incorporate new technologies that have presented challenges to international law, like biometrics, artificial intelligence, and predictive analytics?
Great, that's a fantastic question. I think in general, we need to be careful about thinking about the cyber arena as one that is best conceived of through a war paradigm. I think we have a tendency to kind of, when you've got a hammer, everything looks like a nail. And, when you've got a war paradigm, everything looks like it fits. But cyber, I think, is better understood in most instances as fitting within a criminal law paradigm. Many of the actions that are being taken by individuals in the cyber arena are properly thought of as criminal behavior or cyber vandalism or mischief making. Now, that's not to undermine the damage that's being done. It's significant damage that's being done. But I think that we need to be careful because of the very fact that once you start thinking about this in the realm of conflict and in the realm of armed force, then it doesn't cabin the response to the cyber realm, that it is possible that we're going to see kinetic responses. And so your question is particularly looking at the question of cyber terrorism. I think a way in which we've seen that terrorists have most used cyber occasionally for attacks, cyber attacks, but primarily for propaganda, for organizing, for getting members, occasionally for getting money and resources. Those have been the main goals that terrorist groups have been seeking using cyber means. And so we shouldn't necessarily think that the right response is to treat this as if this is a military challenge. That is really, much of that is almost like a kind of conspiracy to commit criminal action. We should be thinking about some of these criminal law tools, as well as shutting down propaganda that really is potentially quite dangerous and could lead to use of force, although obviously that runs into some questions about free speech. But those are the kinds of tools I think we should be thinking about when it comes to the way in which terrorists are actually using the internet, are actually using cyber techniques, that we shouldn't treat every problem as if it can be dealt with the same response. Different problems in the cyber arena require different kinds of responses, and that is true whether you're dealing with a state, whether you're dealing with a particular individual cyber criminal, or whether you're dealing with this terrorist group. But you should take the problem that you have and try to use the tools that are most appropriate to the particular problem that you face. And that may mean sort of shutting down their access to money. There are other ways in which you can go after terrorists that doesn't necessarily mean putting it in the realm of armed force.
Thank you.
Thank you. Yeah, thank you. Well, we have a lot of questions in the chat. So maybe I'll try to sort of combine some of them into some strange amalgam. I was thinking when you were speaking, and some of the questions in the chat evoked Tom Frank's old article, Who Killed Article 2.4? And so one of the questions says, with all this expansion of the quote exceptions so that they sort of become the new rule, how has that impacted the effectiveness of Article 2.4? And then I think I might tack onto that another comment / question, which is, how can we get the voices of the global South and the states not using force to help shape this conversation? So I think I've sort of combined 3 questions there.
Yeah. Great. I mean, so lots there. I want to write this down before I forget. So yeah, so I think that on the Tom Frank, in many ways sort of was ahead of his time always, and was prescient. I think, though, he was a little early in declaring the death of Article 2.4 in that article. So he sort of bemoaned the death of Article 2.4, and I think what that ignores is the fact that 2.4 has actually, in many ways, been remarkably successful. I mean, we can all point to the problems with it. Obviously, there's violations that that we could probably off the top of our head name a number of instances where states have violated Article 2.4. But if you look at the rate of interstate war before the UN Charter was put in place and the rate of interstate war after the UN Charter was put in place, they are very different. The rate of interstate war has fallen dramatically. States generally are not going to war against one another in the modern era. And at least part of the reason for that is Article 2.4. I mean, there are a number of other, that's backed by nuclear weapons. There's a lot of other reasons that we can think that interstate war has fallen dramatically. But it has fallen radically. Just looking at the numbers, we live in a much more peaceful world when it comes to wars between states than has been true for much of the time that we've had modern states in existence. Now, I think what we are seeing is a kind of radical erosion of that. And I think we have, part of what the book that Scott and I wrote was trying to do is say, we should stop taking this for granted. We've lived in this world, most of us who are alive today have lived in a world that's, most of our lives have been ones that have enjoyed the protection of Article 2.4, and where states are not constantly in fear of being invaded, and where conquest isn't the ordinary practice of states, and where gunboat diplomacy isn't accepted as permissible. And it's easy to forget that is relatively new. And for all its foibles and for all the various violations, I mean, I'm the first to admit that those are problematic, that has been remarkably successful. But it's not going to last forever if we don't try to maintain it. And we have the responsibility to try and maintain it. And I think what's so sad for me about this moment is the very states who championed this international legal order are the ones who are putting it at risk. The ones who are in the position to really say, this is a prohibition, the prohibition on force is essential to our international legal order. we should be maintaining it and should be doing everything they can to shore it up. And yet the opposite is happening. The US, the UK, France, Russia, and China, unfortunately, they're the ones kind of that are eroding it, that are leading the steps down the road towards its undermining. And at a certain point, it's going to collapse altogether. And the question is, when do we reach that point? But I think we're not quite there yet, but I think we're getting awfully close. And that's the thing that worries me. How do we bring in more voices? I mean, this is a really important question. And I think in some ways, we see a moment where, in a sense, as awful as the pandemic has been, and it has been truly horrific, it has created the possibility for international conversations like the one we're having right now. We have people from around the globe participating in this conference. And we have people from many different countries who are able to be a part of this conversation. And I think that does open the door in a way that we haven't seen before to a more global conversation. I think it also means that we have to make a real effort to reach out. And I think the kind of effort that Mexico is making, that is mentioned in the chat, I think is really important. I participated yesterday, and Jennifer, who gave a comment in the chat, participated as well in an initiative that the mission of Liechtenstein has put forward to try and apply the Rome Statute to cyber conflict and work through how does the Rome Statute apply in the cyber context, and has written this big report on that. And there were a number of states that were sponsors of that same report. So the ways in which the small states, if they choose topics that they really want to focus on, the states that haven't traditionally had significant voices in this space, I think they can be most effective if they do something like what Liechtenstein has done or what Mexico is doing, is choose a topic that they can champion, that they can bring in experts on, where they can convene people together to work on these issues and try to develop their perspective and get it circulated out there. I think that's a really important development, and I think modern technology makes that easier than it has ever been before. I think also people like us have to be listening and looking for it and recognizing how important that is. So the rest of us who are sitting in countries that have traditionally had outsized voices in this conversation should ask when someone tells us, oh, this is customary international law. Like, okay, what states are behind this? Oh, it's only 10 states that have endorsed this view. Maybe I shouldn't be so confident saying that this is international law until I've seen a larger swath of states that have been consulted, and that there's more of a kind of contingent of states that stand behind this view, and ask the question, well, what do the states who are silent think? And I think that's a role that all of us can play.
Thank you. Nawi, over to you.
Yeah, and I think I'll adapt one of the questions from the chat. So in his new book, Sam Moyn argues that the humanization of war, particularly through the use of modern technologies, has played a role in subverting the more radical goal of peace. And so I would be interested to hear what you make of that thesis, and also if you view cyber warfare as potentially one of those technologies.
Yeah, it's such a great question. And Sam, of course, is my colleague at Yale Law School. And I read his book in draft and found it provocative and fascinating then, as I do now. I think that Sam makes an important point that sometimes gets lost in the controversy over his article, over his book, which is we have spent a lot of energy on humanizing war, and in the process maybe lost sight of the thing that was most important, which is whether war would be waged at all. And when we're focused so much on kind of getting the rules exactly right and losing sight of the broader implications of a, say, counterterrorism policy that rests on drone warfare the world over, we maybe lose sight of what matters the most. I think where I'm not sure I'm on the same page with Sam, and I'm not sure he necessarily would argue this either, is that an implication of this is that we should sort of stop trying to make war humane and, kind of let it be bloody and brutal, and then, if it is, then it's less likely to happen. Unfortunately, I'm not confident that would be true. And I don't think this is necessarily raising questions about the efforts that those of us who have worked hard and believe in the humanizing rules for international humanitarian law, that we're wrong to think that those are incredibly important. But I do think, when I worked at the Department of Defense, I will say, the question is often asked when there's a drone operation being planned, does it fit the international humanitarian law rules? Does it meet the principles of proportionality and distinction, et cetera, and necessity? Like, are these rules, being followed? And not as much of a question of like, is this policy of using force to achieve these ends really the right way to achieve these ends? If we have these tools, we have the capacity to project force the world over, and we can have drones in the air pretty much anywhere all the time. But should we? Should we? Is that really the right way to be running a counterterrorism policy? Is that the right way for a country that believes in humanity to be achieving those ends? And I think part of what's powerful about Sam's book is that it forces us to ask that question, and it does say we've lost sight of something in the way in which we've developed our counterterrorism policies, and in the way in which we've adapted a position towards war, which is so mindful of getting the use of force right, in a sense, following the rules, but not always thinking as carefully about whether the use of force in the first place is necessary. So in that sense, I do think he's got a point. For all the controversy that he's stirred up, I think he's done something useful in making us ask that question, and challenging us to really think about the increasing reliance on military force, and the failure to really think carefully through whether that really is the country that we want to be.
Thank you so much, Oona. And I agree with you. I think Sam makes a profound point there that we have to go back to the original question of how can we eliminate war, and then we don't have to worry about war crimes. At the same time, those who are trying to do what they can to ameliorate the suffering of war while we wait for that golden moment, I think are working hard to do that. We maybe have 1 minute for one other question. There's a couple questions, one about protection of nationals abroad, one about 2.4 saying that you can't use force against the territorial integrity or political independence. Does that mean other kinds of force could be useful? Do you want to just say in 2 minutes anything about sort of the contours of 2.4 and how strictly we should read it in terms of the exceptions?
Sure, I can say a few words about this. I think that on the protection of nationals abroad question, I think that we have been too quick to embrace a really strong view of protection of nationals abroad, and this would be heresy at the Department of Defense. I will say, from my old colleagues would really be unhappy with me about this. But one real danger that I think in adopting a really strong protection of nationals view and expanding it to include armed forces, as we do now, is that whenever you send forces around the globe, there's kind of like a possibility of radiating use of force that comes from that. Because as soon as those forces are on the ground, the possibility of their being attacked, anyone that attacks them suddenly then becomes a subject of response in self-defense. And that can create much greater justifications for continuing to engage in military force. And we're seeing that with exactly what's happening in Iraq right now. We have U.S. forces on the ground in Iraq being attacked by Iranian-backed groups, which was part of the justification for the use of force against the Iranian general. And so that causes this radiation out of use of force. And I think we have to cast a more critical eye on whether these are really the kinds of justifications that fall within the original understanding of Article 2.4 or a shared understanding of the appropriate expansion of Article 2.4. And in that sense, I think we ought to be more cautious about those expansions. And I also think that this is another instance in which the states that are using force are the only voices that are being heard. So the states that are using force in protection of nationals, which is the U.S., and as I mentioned, it was a justification that was being used by Russia as part of the justifications for taking Crimea, and it's also been used for to explain its use of force and support for separatist nationalists in parts of eastern Ukraine. These have consequences. These have consequences that we all have to suffer, and it shouldn't be the case that states can individually make these choices and shape the law by themselves. I mean, this is international law requires some agreement among states, and unfortunately, we've gotten to the point where individual states are making these arguments on their own and not being challenged sufficiently. And I think that's part of our job, is to push back. Our job as lawyers and as specialists in this field, as practitioners and scholars, is to challenge them to really explain whether this justification is actually well grounded and whether it's shared by other states or just by the states that want to use military force under these justifications.
Thank you so much. I wish we had another hour, but we don't. Please, everybody, join me in giving a warm round of virtual applause for our amazing speaker. Oona Hathaway of Yale Law School did an amazing job, and we're so grateful to you for your leadership, for your scholarship, and for spending time with us here today as part of International Law Weekend. So thank you, Oona.
Thank you so much for having me. Thanks for all the engaged questions. I'm sorry we weren't able to get to all of them. There's so many great questions, but I hope that as many of you are colleagues and friends, I'll look forward to continued conversations in the days and weeks and years to come. So thank you so much for inviting me. Thanks so much, Leila, and thanks to everyone. Thanks, Nawi, for moderating. Thanks for everyone for being here.
Yeah, and thank you to Nawi as well. And now everybody, you can join one of our networking and publisher rooms, or you can grab some lunch and then join. Thank you so much, and see you back in another Zoom room in a few minutes. Bye-bye.
Thank you.
Thank
Bye.
you.